Sorry. Hi, good afternoon. Thank you for taking the time to hear this bill. I'd like to respond to a few points that have been made and then give my statement and then just, react to a few more points that were made. I think it's important to note that if an individual is found not guilty, the bond is returned. Except for veterinary care. So institutional care costs would be returned to that individual along with the animal. And I think it is worth noting, Assemblyman Hotaling, you asked Ms. Cucciaro about, why does she think that individuals are innocent? And she mentioned the case of a dog that was found in a park. If there were a loving owner to receive that dog, the dog would be returned to that loving owner. The dog was taken into the shelter and possibly reunited or not reunited for reasons having nothing to do with this bill. And actually, this goes to the point that was last made that everyone considers their animals to be pets, to be their furry animals. My dog is lying at my feet right now. This has nothing to do with those people. This has to do specifically, explicitly in the bill, where animals are found. The standard is that a court agrees with the shelter. Everything court has to approve everything. A court agrees with the shelter that at the time of seizure, the animal required veterinary care or needed protection from harm. And the bill lists the kinds of evidence that the court could consider in determining whether that animal at the time of seizure, in determining whether a bond should be awarded, what sort of evidence what should be considered when as to whether that bond should be awarded would be the condition of the animal at the time of seizure, the conditions of the other animals that the animal is living with at the time of seizure. And again, whether veterinary care has been given to that animal at the time of seizure or not given to the animal at the time of seizure. We are not necessarily talking about people who love their animals. However, we might be. And that's why there has to be a hearing in every single case so that a court can assess whether they agree with the shelter as to whether a bond is appropriate. So there are multiple layers, and this actually will now dovetail with my statement. There are multiple layers of due process that are embedded in statute, in the Constitution, and in this legislation.
Hey, Deborah, can I stop you right there?
Of course.
How long does that process take from seizure?
So the shelter has 30 days to file this action to obtain the bond. So first there's seizure. And the seizure is and the rules around seizure are embedded in the Constitution and in statute. Law enforcement has to obtain a warrant to seize that animal based on probable cause that cruelty has occurred, or there has to be an emergency situation where the animal is in imminent harm. So there's that layer. Once the animal is seized, a shelter has 30 days to file this action to obtain the bond. The hearing has to be held within 20 days. And then the individual, if the court determines that the cost that in fact the animal at the time of seizure required veterinary care, meaning they were not being given veterinary care by their owner that they were entitled to under the cruelty law, as Brian Hackett mentioned, and I think it was noted elsewhere or by someone else, the cruelty law, that is one piece of the cruelty law, deprivation of necessary care, including veterinary care. So if the court agrees that at the time of seizure, the animal required veterinary care that they were not receiving, or they were in imminent danger of harm, needed protection from harm, apologies, then they agree that a bond should be assessed, they would then review the expenses, the costs that the shelter believes are reasonable. It is not just the shelter pulling a number out of their, you know what? It is the court. The court would have to agree that these are reasonable costs. And then the bond would have to be put up within 7 days. And then every 30 days thereafter for the care of that animal. I will note, and this goes to the issue of, I've heard various things. Some people said that the bill has floated around for 3 years because, it's obvious because of, there are problems with the bill. Some have said that we went too fast on this bill. I can assure you a lot of care, a lot of thought was put into this bill. We discussed this at length with the Administrative Office of the Courts, which is the agency that would be tasked with overseeing this. They actually, one of the amendment that you would do in committee, which is the removal of subsection D, they want to ensure that the court has the ability to waive this bond where someone is truly indigent. The original version waived it only partially. It did not waive the veterinary care, it waived institutional costs, but the AOC wanted to ensure that the court had ultimate authority to waive bond for indigent individuals. So that's been covered. Every aspect of this bill has been considered. And I guess if I could, I would like to go now to my my
I have
statement.
one more question.
Oh, I'm sorry. Please.
What would make a case like this linger? What would keep an animal in a shelter for 30, 60, 90 days?
Well, actually, what this is actually intended to go to is that these cases can go on for months or years. And that is not unusual. I think every shelter in this state probably has an animal in its care, has an animal in its care, because of one of these cases that has gone on at great length. There are issues in the system that just in terms of I think now I see what you're getting at. There's the cruelty case, which is moving along. And then there's this proceeding. This is a separate civil proceeding that would be allowed to occur in acknowledgement of the problems in the criminal system that may cause a case to be prolonged. I will note that I had a discussion with some individuals, law enforcement involved in prosecution in New York and Connecticut. And one problem is owners who use these animals as leverage. And so these animals, linger for a very long period of time. Hoarding cases, animal fighting cases. One thing to note, I get this point. Again, I guess this goes to the indigence question. There are going to be people who are indigent. There are people who are going to be unwilling to pay for the care of their animals. The question is whether we want these animals to linger, be it in the shelter or in foster care. Not all animals can go to foster care because the criminal case has been prolonged. And it does matter that this is living evidence. This is not a lamp. This is not a couch. This is a living creature who can break down in the shelter or even in a foster situation where there's a lack of permanence. It is, so in short, these cases, the criminal part of these cases can go on a long time. And because these animals are the property of the owner, they can be held on to by the owner for the length of the criminal proceeding until final disposition, which can take months or years. It is our assertion that, and I am a New Jersey resident. I know there was an individual from Minnesota who testified. I'm a New Jersey resident, so although I represent a national organization, I'm based in New Jersey, that this bill is an absolute good for New Jersey, that we have no choice other than to pass this bill. Obviously, you have a choice. I'm hoping that you see it this way. Assemblywoman Swain, I appreciated your comment at the beginning where you noted how that you appreciate the fact that you have the opportunity to do good things for animals. I know that some individuals in this proceeding have attempted to sow doubt regarding this. This is an absolute good for animals. There is no choice if we want to be compassionate to animals, this is necessary to ensure that animals are not lingering in shelters for an excessive period of time pending final disposition in the criminal case. And I'd like to note that it is the fact that animals do linger in these shelters that are often in the red. They often don't receive enough money from their municipalities. They are not prepared for large-scale animal cruelty cases. These cases, large cases, are not pursued, and even smaller cases. I've been on the receiving end of many calls from advocates and made many calls to law enforcement where it's clear that cases are not being pursued because there is a lack of space for those animals. They're not sure where to put the animals. Just recently, there was a case, and I noted this in my written testimony. There was a case in New York and Connecticut involving 100 dogs. Both New York and Connecticut have cost of care laws. And by virtue of the fact that they have those laws, those almost 100 dogs taken out of very, really bad circumstances have been able to largely move on. That case would have a different conclusion in New Jersey. Those dogs would still be in the shelter, or just as likely, if not more likely, the case would not be pursued because there simply isn't the space to handle those animals. And it is impossible, it would not be possible, even if one wanted to indict the large nonprofits advocating for this bill. It is simply not possible that these organizations could handle all of the cruelty in this state and across this country. It is necessary that and this dovetails in my statement that I would have read. It is, and Mr. Hackett, Brian alluded to this, an individual who's responsible for their care prior to seizure should not receive a net benefit from a seizure, where they're responsible for the care of those animals prior to seizure. That is what the cruelty law says. And then after seizure, they no longer are responsible. It is the responsibility of the shelter. I'd also like to respond to the issue regarding, I know the AKC has attempted to sow some doubt regarding this bill, the Federation of Dog Clubs. The AKC and the Federation of Dog Clubs are looking for protections that they don't receive under the current cruelty law. In our opinion, they should put in their own bill for future consideration. But this idea that co-owners they have no stake under the current cruelty law. What would happen is an animal would be seized under the current cruelty law. They would go to the shelter. There might be some, negotiation with co-owners. Prosecutors would determine does that co-owner have clean hands? And a breeder is not a co-owner, unless the breeder actually is also a co-owner. But a breeder that sells the animal, they are no longer, and divest themselves of ownership, they are no longer owners. To the degree a breeder is a co-owner in any given case. Right now, under the cruelty law, the prosecution would investigate whether that co-owner has clean hands. We certainly have seen cases involving puppy mills where one puppy mill owner, they just simply shift ownership of the puppy mill to a family member, or it could be a dog fighter who then the co-owner is another dog fighter. That investigation would have to occur right now regarding regarding those co-owners and whether they actually have clean hands, and then some final determination would be made. If a co-owner genuinely has clean hands, there's nothing in this bill that would prevent the co-owner from putting up the bond for that animal, pending final determination in this case. The purpose, and then it's just status quo. The sole purpose of this bill is to ensure that shelters receive the money for care that they are currently outlaying in spades and can't really afford, and to ensure that other cruelty is investigated and that the shelters are able to meet the needs of other animals, other homeless animals. So I think so the AKC is looking for some kind of protection for co-owners that they don't get under the current law. And this bill would not prevent a co-owner with clean hands from paying for that bond pending investigation. I also would like to note regarding the neutering issue, while it is dismaying to an organization like, to me personally, and to an organization like mine and others advocating for this bill, that, that the AKC would look at these desperate animals in these terrible cruelty cases when seizure occurs very minimally, very rarely, and see really just a vessel for reproduction, that's disturbing. But aside from that, given that these animals are property, the bill actually does address the issue of that only a veterinarian must determine whether a medical procedure is necessary. So right now, there would be nothing preventing a veterinarian from assessing an animal as needing a spay or neuter and that occurring, that's been seized as a result of cruelty. And certainly there are a lot of cruelty cases involving the reproductive areas of these animals, tumors, prolapsed organs. So this may actually be necessary, and a veterinarian could make the determination right now. So they're looking again to the assembly for protections concerning sterilization that they don't have under the current cruelty law. And if they want that considered, I would suggest they put in a bill. So if you would just give me just one moment, I just want to make sure that I'm covering the bases. I do want to note that we represent over 180,000 people in the state of New Jersey, including myself, and and my colleagues also represent hundreds of thousands of individuals. So I think we certainly represent people who couldn't be here today, and I guess certainly I don't want to read. I think I've touched on all the points.
Yeah, yeah.
Yeah. I would like to note this because we were together once before concerning the dangerous dog issue. And I would like to note that this bill, I know that bill didn't move forward, but this actually offers a constructive approach to the dangerous dog question because there is a strong link between cruelty and the dangerous dog issue. Dogs who are not treated well are predictably, they're resident dogs, they're not family dogs, are more likely to be dangerous. And it seems that it makes sense. A6099's emphasis on ensuring that dogs be allowed to move on to new lives more quickly when their owners mistreat them makes a lot of sense. So in conclusion, I would simply like to read you a quote from a volunteer who had to saw the results of not having this law in in New Jersey. And this is really brief. This is a moving plea from New Jersey shelter volunteer. I'm a dedicated and passionate volunteer at a shelter, and there are past and current instances where we have court-seized dogs due to criminal charges and currently have a hoarding situation with multiple dogs. I realize a big point in this bill is the devastating effects on budgets of shelters, and taxpayers are funding the cost of care. But I am here to state is the animals being kept in 4x7 kennels indefinitely while these court hearings go on, it is worse than any money being lost or spent. And again, foster care is not available to many of these animals. Think roosters seized in a cockfight, dogs taken from fighting situations. These court-seized dogs live their limbo life in these kennels, being absolutely cared for by staff, feeding, cleaning the kennels, but not allowed exercise, not available for adoption. This is a true injustice to these dogs. And there are times after so long, these dogs go crazy, as would any breathing life being held in their condition. Please pass A6099 out of this committee.
All right,